Good afternoon, and welcome to today's webinar, Transparency in Theory, Confusion in Practice, Understanding the Corporate Transparency Act. I'm Martina Pickett, a staff attorney at the DC Bar Pro Bono Center in our Small Business and Nonprofit Legal Assistance Program. And my colleague, Christine Kulumani, is managing attorney in our Small Business and Nonprofit Legal Assistance Program and will be co-hosting this webinar with me today. Special thanks to our colleague Lauren Paley, who has made the technology possible as well as the registrations. And before we get started, there are a few logistics we'd like to go over. First, this webinar will be recorded, and the recording will be posted on our resource website. You are able to download the slides from tapping the Materials tab on the GoToWebinar control panel, and the slides will also be posted after the webinar. If you have any questions as we go, you can add them to the questions tab in the GoToWebinar panel. However, due to the transient nature of today's topic, we may not be able to answer every question. This is an informational webinar where we are not able to give one-on-one legal advice. So if you would please keep your questions as general as possible. Okay, so as you know, we're here to discuss the Corporate Transparency Act, and we'll start by just giving a little background regarding the act, why it was enacted, and what you should know about it. So the Corporate Transparency Act, also known as CTA, was enacted in 2021, and it went into effect on January 1st, 2024. It was a part of the National Defense Authorization Act. The CTA is a federal law that requires certain businesses to report information about their owners and how the business is controlled. The intended purpose of the act was to prevent money laundering, tax fraud, and other financial crimes, as well as human trafficking and other legal activity, while encouraging transparency in corporate ownership. Prior to the CTA being enacted, there weren't any federal requirements for companies to disclose their true owners. And so this made it a lot easier for corrupt owners and wrongdoers to hide behind layers of corporate entities, which is the primary motivation for that. So, as I stated, one of the main purposes is to prevent financial crimes and to make sure that there's a way to monitor those engaging in illegal activity. And this is because the US has been criticized over many years for allowing anonymous shell companies. And these shell companies enable illicit financial activities like money laundering, tax evasion, and fraud. Many of these companies operate as small anonymous entities rather than large corporations, which is why the Corporate Transparency Act is geared at requiring small businesses, particularly, to register their beneficial owner information. Bad actors often hide behind the illicit funds in LLCs or private entities because of the lack of state requirements and documentation requirements required under state law.
Okay, so as Martina mentioned, the Corporate Transparency Act requires reporting. But what does that reporting mean or look like? So unless a reporting company, which we'll break down, is exempt, they have to file information on their beneficial owners with FinCEN, the Financial Crimes Enforcement Network. And FinCEN is part of the Treasury. So thinking about, okay, we have this reporting, we know what's required, but what is a reporting company? Unless exempt implies there are exemptions. What is a beneficial owner? Is that just an owner? Martina mentioned control. So alluding to that a little bit, what information needs to be reported and when to report. So we're going to break down all of those. And I want to flag for you that if an entity was created beginning January 1st, 2024 or afterwards, They also, in reporting, will have to file who the company applicant is. That sounds fancy and scary, but a company applicant is actually the person, whether it's an owner of a business or a lawyer, who filed for the entity to exist, who filed the articles of organization or articles of incorporation or other creation document with the state or local government. So what's a reporting company? This is important to sort of figure out, does your business even need to worry about the CTA? A reporting company is a domestic entity, and domestic here means US, and in a state, created by filing of a form or a document or a piece of paperwork with the Secretary of State or similar office for the entity to exist. So here in DC, the Secretary of State or similar office is going to be the Department of Licensing and Consumer Protection. Formerly, it was Department of Consumer and Regulatory Affairs. In Virginia, it is going to be the Virginia Corporation Commission. In Maryland, it's the State Secretary of State. Other states, it's generally Secretary of State, but it is where you file that paperwork to exist. And because you need to file that paperwork to exist, if you're a sole proprietor or a common law partnership, where you just exist by virtue of doing the business and no separate legal person is created, you are not a reporting entity. If you have an LLC or a corporation, you are a reporting entity. Even if that LLC was formed and you're not actually operating a business under it. The LLC and corporation exist, so you need to report. Or you are a reporting entity. Okay, exemptions. Well, which entities don't have to report? Bad news, potentially, is that most of the exemptions don't actually apply to small businesses, particularly micro businesses. A lot of the exemptions are related to entities and businesses that are in industries that are highly regulated by the federal government. So the government already has this information on them. The two biggest exemptions that may apply to some of you are those that are tax-exempt organizations. If you have a nonprofit corporation that has 501c3 status from the IRS, you are exempt as a result. The other exemption that may apply to some of you is being a large operating company. And this has 3 requirements. The business needs to meet all 3, check all 3 boxes. More than 20 full-time employees in the US. Number 1. Number 2, have a physical operating presence or office location in the US. And generate last year more than $5 million in gross receipts or sales. All 3 of those must be met to be exempt as a large operating company. Keep in mind that this could change for a business from year to year if they're exempt or not under that rule. You're a reporting company. You're not exempt. Well, what goes in the report that you now have to file? You can see on the screen a picture of part of what the report looks like and some of the basic information. So for the entity itself, the reporting company, the legal name that was registered with the government, any trade names, also known as DBAs or fictitious names, the current street address of the business, the jurisdiction where the entity was formed, so that would be the state or the District of Columbia, where it was formed, not where you are currently operating, or everywhere that you're registered as a foreign entity or to do business. This is where the legal home is, whose corporation or LLC laws govern. And then some form of an IRS taxpayer identification number. This might be an employer identification number, which most businesses should have. Otherwise, it can be an ITIN number or a social security number. That's for the company. And for each of the beneficial owners, or that company applicant, the person that filed to form the organization, full legal name, date of birth, current address where they live, information from either a driver's license, a passport, or valid US issued ID. And if they don't have that, a foreign passport. And not just that information, but also uploading an image of that ID document. So a picture of, that main passport page or the front of that driver's license. So we have to give the information on the entity, and then beneficial owners and company applicants. There are 3 buckets of information. But what are those beneficial owners I keep talking about? A beneficial owner is an individual who indirectly or directly exercises substantial control of this reporting company or controls at least 25% of the ownership interest. There are some exceptions here, but most of those are very nuanced and detailed. Anybody that owns 25% or more of the business. If there's only one owner, they definitely meet that requirement. Substantial control is a little iffier. This is soft. People that are senior officers, if you have officers, they have the ability to remove or make changes to senior officers or the board of directors, or they're involved and have some say, like big say in important decisions. Lines of business, where they're operating, disposing of real property. And there must be at least one beneficial owner. So if you have an LLC with 5 owners, and each person has equal ownership of 20%, nobody has the 25% or more ownership interest. But at least one of those people, or somebody related to the entity, exercises substantial control. So we want to keep that in mind. There will be at least one beneficial owner. So when do you have to do this? When is filing required? Well, we're going to talk about in a minute a lot that has been happening that has just skewed all of this. But under the law, new entities, reporting companies that were created January 1st, 2024 to January 1st, 2025, have up to 90 days to file their first report. Starting January of this year, 30 days to file reports. If your entity existed before January 1st, 2024, the initial deadline was January 1st, 2025. Updates are within 30 days of information about beneficial owners changing or finding out that information was incorrect. This is what the law says. The important parts are existing entities will have a deadline that they need to file by. Right now, we don't know what it is. And newly formed entities will have 30 days from now on, once they're required. And updates are always within 30 days. I mentioned all of that is in the law. It is theoretical. And it's confusing. And that is because there are court cases and lawsuits that have impacted all of this right at the last minute before that January 1st deadline. So Martina is going to walk us through some of that and get us up to speed to the best of what was happening right before we logged on.
Great. Thank you, Christine. So we're going to discuss the litigation updates and impact. And I see that there's been a little bit of concern in the chat already about the litigation and what that means for filing this beneficial owner information. So hopefully this provides a little bit of clarity. And as a reminder, the law is consistently changing, and this is information that we have as of today. But it could really change tomorrow, and there's nothing we can do as far as the litigation is concerned. So for a quick timeline review, January 1st 2024, the Corporate Transparency Act reporting requirements became effective. Entities created or registered before this date were required to file their initial reports by January 1st 2025. However, a few weeks prior to the January 1, 2025 deadline, a federal district court in Texas issued a nationwide preliminary injunction. And so, what this did was that it temporarily halted the enforcement of the Corporate Transparency Act due to potential constitutional concerns. Someone brought the case, they claimed that they believed it was unconstitutional, and because of that, the district court said that reporting was not required and there's an injunction until further review. However, a few weeks later, on December 23rd, 2024, a Fifth Circuit Court of Appeals stayed this injunction, which essentially is somewhat of a reversal of the original action, which means that they reinstated the reporting requirements and set a new compliance deadline of January 13th, 2025. So at that point, they did extend the deadline because of the court's original ruling. And again, this was a reversal of what happened on December 3rd, 2024. But as you can see, 4 days later, the Fifth Circuit vacated its previous stay. So at this point, essentially, this is a reversal of the reversal, where the injunction is now back in effect due to a second court case that was brought with constitutional concerns. And then this also paused the enforcement pending further judicial review. So as of December 27th, 2024, the injunction is in place and there are no reporting requirements. So the current status is that despite a favorable Supreme Court decision for the CTA, the second injunction that I just mentioned remains in effect and it prevents the law from being enforced. However, FinCEN advises that reporting companies are not required to file the beneficial ownership information while the injunction is in place, but they may voluntarily do so. So if you were to go to the website where you input your beneficial owner information, there's nothing there that's going to prevent you from filing that information. And there's not going to be a penalty for filing it. And right now, there's not a penalty for not filing it, but you have the option to do so. As of February 2025, a second nationwide injunction was appealed by the Treasury. And upcoming, we have a ruling on that second injunction. For the motion to stay the preliminary injunction is expected in the next coming months. So the bottom line is that you're not required to file this information as of right now. There's no penalty if you do not file it. However, you do have the option to file it, especially being that we don't know what's going to happen with this in the future. So if you would like to file it, you have the option. And I think Christine's going to touch on more about your options when it comes to that and what you can do in a situation. We have a question in the chat that I do want to address. What will the data collected under BOI be used for? I'm very concerned about the use of this data by the administration for anything but financial crimes. For example, will FinCEN share BOI information with law enforcement for immigration enforcement purposes? What about tax compliance? So what we know is that the act was enacted to prevent financial crimes. It's really hard to say whether or not this information will be shared with other agencies, especially under this new administration. But the purpose of the act is for financial crimes, and so it's hard to advise on whether or not it will be shared for other purposes. Do you have additional thoughts, Christine?
Yeah, so there are regulations like sensitively, strictly limiting who can get this information. But law enforcement agencies at the federal, state, tribal, and local level can apply to FinCEN and say we have a legitimate law enforcement purpose. And FinCEN then decides who can access that information. How that plays out, we haven't had enough time to see yet. And what a legitimate law enforcement purpose is could mean a lot of things. So it could mean, part of what this law was created for was, financial crimes. Tax evasion is a financial crime, money laundering. And so, yes, it could be related to taxes in that sense and accessing it for that reason. But there are some other law enforcement purposes that are less clear. So immigration is a great question. We don't have an answer because enforcing immigration laws is a law enforcement activity under strictly those words. But yeah, will ICE be able to get an address from a beneficial ownership report under that justification? We don't know. And given what has been happening, there are these policies and procedures in place, but whether they are upheld or not is to be seen. Also, I will say that the information that is filed with FinCEN under this, if the filer gives consent, can be accessed by certain financial institutions. But that requires you affirmatively saying, yes, X, Y, and Z institution can get my beneficial ownership information. When it comes to law enforcement and government, wait and see, like Martina said. Yeah, there's so much we don't know. Okay. So now what? Where do we go from here? Martina mentioned filing right now is voluntary. You're not required to file as of this exact moment. So you need to decide whether to voluntarily file or not to. If you're filing, you must do it online at fincen.gov/BOI. And it must be done online, either through filling out the information, like typing it into their boxes, or using a fillable PDF and re-uploading that. If you're not going to file, that is fine, and we'll weigh considerations for that in a sec. But you will need to keep up with court cases, any deadlines that FinCEN sets if injunctions are lifted, and legislation. that might impact this. So when we're thinking, okay, file, don't file, what goes on what side, how do I think about it? If you are thinking, okay, in favor of filing, you don't need to watch updates as closely because you have filed and you have less of an immediate impact. There is looking to be increased chance that at some point you will be required to file. We don't know for certain, but things are looking that way. The current administration has been moving forward with appeals to say, actually, we are standing behind the law and we intend to enforce it. Filing is free. The actual filing of the report. So there's not necessarily that financial cost. And then for those entities operating in DC, you have already provided information on beneficial owners at even a lower level, 10% ownership, to the DC government. So if you are registered with DLCP, you have had to figure out who your beneficial owners are. So you know that. It's not a test or a task. There's not a ton of more effort to sort that out. But when thinking about, okay, well, why might I want to wait? Your business has, honestly, just things that are more important to do than this. It is relatively quick to file, but figuring out the information, getting documents, being on the right computer, taking time to just do it, we'll see. Also, as was alluded to, with where the information is going, there's a lack, but we don't trust necessarily what this data is used for or where it's going. A lot of people were concerned about this previously, in 2024, and the concern seems to have grown a lot, wanting the government to not have access to this, particularly unnecessarily, for invalid reasons or for harassment. Okay. I mentioned that it's looking more likely that at some point your business is going to have to file if you're not exempt. But it could ultimately be unnecessary. We do not know. We really, really, really do not know. If you wait, you're not risking any fines. You're not required to report right now, so they won't slap a fine on you. If an injunction is lifted in the near future, and there are no other injunctions at that point, FinCEN has said repeatedly that they will give a 30-day grace period for that initial filing. So you'll have time to do it in the future. And then once you file that first report voluntarily, if the information changes, you potentially, even if the law has that preliminary injunction, you then will need to start likely updating the information if it changes. This is something that has not been tested, but many experts in the field have the understanding that if you voluntarily file and then beneficial ownership information changes, you then have an obligation to update it. You don't want to be the test case for that. I don't imagine. Or if you don't expect the information to change, you don't have to worry about it. I mentioned keeping up with legislation. Protect Small Businesses from Excessive Paperwork Act. This is a piece of legislation that had 12 co-sponsors. It was bipartisan co-sponsors in the House, and it was passed on February 1st. I think it was actually February 11th, but I could be wrong. I might have mistyped the ones. But it was recently passed by the House of Representatives. So there was some traction. What the law does is it delays filing for existing entities before 2024 to January 1st, 2026. So there's bipartisan support in Congress to keep the CTA going. It would not impact the 30-day filing requirement for any newly created entities. There's a companion bill that does the exact same thing that has been introduced in the Senate. The Senate seems to not have it as a priority, and there are other things that they are focused more on passing. So we will see where that goes, but there is potential. How do you keep up with all of this, right? The CTA, it is a moving target all the time. And we never know when what is going to change. Some good ways to keep up are through LinkedIn. You see screenshots? This is what my LinkedIn looks like all the time. If you are on there, connecting with and following folks that are CTA experts, and there are a lot of them. It's a quick and free way to get access to expert information. Setting a Google alert or Google News alert for like Corporate Transparency Act, or putting it in your Google News just as like a saved search that shows up, or whatever news platform you use. Law firms also have newsletters and client alerts that you can subscribe to. You don't actually need to be a client or pay the firm. They're free. You go on their website, their resource page, and sign up. There are two firms here that are smaller that have entire resource sites dedicated to the Corporate Transparency Act, including newsletters. There are plenty more law firms that also have them. Go online, find a newsletter or 5 that fit for you, and subscribe to them. And that will allow you, in combination with whatever works for you, to stay up to date on this. Also, if you are not already on our mailing list from the Pro Bono Center, and you checked the box when you registered for this that you want to be added to it, if something big changes, we will update you. We may not immediately send out a big blast the day something happens, because as we saw, Martina walked us through 4 days and the court completely changed their stance. But we will update you as things change. We will send out emails. There are great resources. Okay. So we'll go through some questions now. We wanted to leave time to get through many of them, but I also want to let those of you who are listening both live or to the recording know that you can talk one-on-one with a lawyer for free legal advice related to your organization through our monthly small business brief advice legal clinic. It can be about the CTA, about beneficial owners, evaluating risks associated with reporting, or it can be totally unrelated as long as it's businessy law. So employment law, contracts, bringing on new owners, fair game. It's a wonderful resource, and I encourage, for those of you who need one-on-one legal assistance, not drafting documents, not in court, but talking through and reviewing legal things, to attend that. We also have a resource site, Law Help, and that's where the recording of this will be. That is where recordings of our past CTA webinars are. Any legal alerts, changes to laws, and upcoming events. You can always go there, and it is really a full resource hub. And I think with that, we are good to jump into some of the questions we haven't done yet. So if you have them, send them in. Let's get going on them. Okay, so how do nonprofits determine beneficial ownership? If there is a nonprofit organization and they have tax exempt status, they are exempt from the reporting requirements, at least at the federal level. If they do not have tax-exempt status, we are going to do that same analysis for a beneficial ownership. We don't have 25% or more ownership of anybody because nonprofits don't have owners, but we'll look at who's calling the shots, who's making decisions. As a general rule, this will include at least all of the members of the board of directors. There could be other individuals that are also beneficial owners. But the general rule, if you are not exempt, start with the board. Let's see. Okay, what does the fine process look like? Do you want to take that one, Martina, or do you want me to?
I'm not familiar with what that process looks like, especially since there hasn't been any enforcement up until this point. So I can envision that it would be similar to any other like late filing, um, where you may not be like a proceeding as you've referenced it, but more of a like a notice and a requirement to pay a certain amount. But again, because there have been no fines, to my knowledge, issued based on the fact that this hasn't been enforced consistently, then I'm not sure what that process will look like.
Yeah, I agree. It's hard to know exactly. But generally it will be they issue a fine for noncompliance, and there may be an opportunity to appeal based on certain grounds, but how long that would take and how it's structured, who knows? And fines under the Corporate Transparency Act are not automatic. It is not you don't file, they magically know you should have filed, and you get sent a notice of the fine and have to pay. There is enforcement action that has to happen by FinCEN, so they choose a fine. In 2024, the stance under FinCEN then was that they were not going to crack down on non-compliance by small businesses that did not know about the legislation or were doing their best to comply. They were planning to crack down on and issue fines to those who knowingly gave false information, who knew they needed to file when it was a legal requirement and chose not to do so to cover up criminal activity. We have not had any update on this under the new administration and where FinCEN's enforcement priorities are. That may come out in the future, or it may not. And it might be another wait and see, unfortunately, which I know is unsatisfying. Let's see.
Are there any more questions?
Anybody has them? Let's type them in now. Okay, Martina, I guess we were able to make all of this confusion understandable for them that they don't have any more right now.
Great.
Oh, let's see. So we have one final question. What is being done as outreach to get the word out to businesses in DC and elsewhere? The Pro Bono Center is working with other organizations that work with small businesses to have them share with the businesses they work with that this is a requirement. Fact sheets, information linking to webinars. And some of the organizations actually don't even work with small businesses. They work with other organizations or in other communities that may have small business owners. The Department of Licensing and Consumer Protection here in DC also sent out a notice to all registered agents in DC about the federal filing requirements. As of last fall, FinCEN was out in the community doing outreach and letting businesses know about this law and marketing it. And different business counselors are also having sessions and information and sending out reminder emails to organizations. So the Small Business Development Center here in DC, and most of their events for about the past year at the beginning just mentions, hey, by the way, this is something coming up. If you have questions, here's how to find out more or get them answered.
And please share our information and the link to our page with other small business owners in your network as well, because we definitely want the word to be out there. We don't want businesses blindsided by this, and it's really important information to know.
Okay, I think that is it.
Well, great. Thank you so much for joining today's webinar. As we mentioned in the beginning, this webinar is recorded and it will be posted after the end of the webinar, as well as the slides. You'll be able to access them as well.
And if you have an opportunity when you log out of this, we would appreciate you completing the survey and giving us feedback on this webinar and other topics that you're looking, the legal topics that you're looking for trainings and information on, so that we can use what you need to plan for what we can offer.
Great. Thank you so much. Have a good day, everyone.